I always forget to do that, so let's start on. Click on the link, put your license number, your brokerage, your name and stuff on Tucker's form. You'll get that CE credit. Tucker's with Backman Title Service. We also have Michelle in the office here. Yep, come on up here. And I'm going to let her introduce Tucker. Obviously, we have these classes every week, and we always have tremendous instructors coming here, and some of them I'm meeting for the first time, just like you guys. Debbie Hart is in our office with us today with Security Home Mortgage, and she's done trainings for us. She sponsors like our mom's panel. She's part of the family here, so she has made this introduction for us, so we're grateful for that. And I don't know why that's blinking off and on. So anyway. So Michelle, Backman title as well. She's in their marketing. Introduce Tucker and let's get rocking.
Want to thank everybody for being here. I apologize that this Tucker is on Zoom. Obviously, COVID has hit their family, and so partly to keep everybody from getting infected, he's decided to do this over Zoom. So we have about 14 different core classes that we can offer. So if there's ever any time you guys need reach out myself or Tucker, and we can get you some hours. But I've been with Backman for 25 years. I strictly work more in the Northern Utah offices, but I was connected to Debbie Hart, which is, in my opinion, wonderful. And I appreciate her opening that invitation for us to come here today. So Tucker is actually one of our well-known instructors up north. People love his classes. He loves interaction. If you have questions, please feel free. He does try to make it very interesting and engaging. So I hope you take away some information that maybe you didn't know and find some value to be able to help people that you're working with that might be in these same situations. So I'm going to turn the time over to Tucker, and those on Zoom, maybe every half hour, if you can just put something in the chat just so we know you're engaging and we know that you're there. That will be great. So other than that, hope you guys enjoyed the class. Thank you.
Hey, Karen, thanks, Michelle. Karen, just to answer your question in the chat, there's a link in the chat. If you scroll up, there's a link for you if you're in Utah here to get your CE credits. Click on that and fill out that form. Okay, Tucker, it's you.
Yeah, I'll put that link in there one more time too, just so it's there in there a few times now. That's great. Thanks, guys. Let's go ahead and get started. We're going to talk about family trusts and real property. Looking at mostly the Utah code. Isn't that fun? We get to look at the Utah code. I know you dreamed of that when you got up this morning. But let's go over a few just housekeeping items. First off, my name's Tucker. I've been a Backman not as long as Michelle has. I only have 21 years. Michelle's got 25, but I'm a licensed title and escrow agent, and I do a variety of things with Backman Title. The purposes of this class, these are what we're not trying to do. Obviously, because I'm not an attorney, I don't want to give you legal advice. I'm not really an estate planner. We're not looking at tax consequences so much. And, some folks think after they take a 1-hour CE class, they become experts and can create their own family trust. Yeah, we don't want you to think that either. So don't, this is just a primer on how to help your clients, especially when they're successor trustees, when they're taking over their mom or their dad's estate. So let's look at a couple of things and understand first that every family trust, or every trust, can be a little bit different. Now, we're talking about revocable family trust or inter vivos trust. With residential real estate, that's the most common type of trust that we'll see. We've seen trusts in Utah, and they're kind of famous, like the Miller family. Before they sold the Jazz to Ryan Smith and his group, they had a different type of trust for the Utah Jazz, and the purpose of that trust was to keep the team in town. You'll also see sometimes a Medicaid protection trust. Those things exist as well. Again, our purpose today isn't to go over every type of family trust. We're just going to concentrate on our family trust, on our Utah family trust. And our family trust is actually part of our Utah code. It's Title 75, Section 7. And the last time I printed everything off or got a PDF of everything, we've got over 350 pages about this topic. What happens when you're with your stuff when you die? So the probate code is part of that, and then our trust code is another part of that. And then we've got another section that's called our let's see, death on, or deed on, or transfer on death deed that we might talk about at the very end of it. But really, we're looking at beneficiary rights and again, those duties of a trustee or successor trustee. So as we jump right into it, creating a family trust requirements are just about the same as creating the requirements for any other entity. One, it's got to be created by someone, a settlor. It has to be for legal purposes, and a trust shouldn't be under anything like fraud, duress, or undue influence. Okay, so you don't go to someone who has diminished mental capacity. You know, oftentimes we hear about this where people will take something to their parents and have them sign it when they're not of right mind. The idea is you're doing your family trust or any estate or any entity that you prepare under sound mind. And the other thing that talks with family trust is it has to be for the benefit of beneficiaries. Your trust has to benefit someone. It can't just be something that benefits you only. Let's look at a couple of things. One of them is the positions of a family trust. So our family trust structure, there's really three areas or three parts of our family trust structure when it comes to individuals. The first section is the settlor or the trust maker. Now, I always talk about this in terms of mom and dad, like mom and dad create their trust. They're the settlers, they're the trust makers. Then you have the trustees. Okay, the trustees have authority to sign and administer the trust. And then that third position is a beneficiary. Now, when mom and dad create their family trust, oftentimes they're the settlers, they're the trustees, and during their lifetime, it's normal for them to be the beneficiaries also. Okay, there is a prohibition though, upon the death of the initial trustees, there needs to be an additional beneficiary. It can't be the same person. Okay, you can't have only one beneficiary and only one trustee. You need to have successors and things like that there. So with most of our family trusts are revocable. That means they're changeable and they're amendable. So you can replace people. So who can revoke the family trust? Well, let's go back to our last slide. Settlers or trust makers can revoke or change the family trust. Generally, it's not the beneficiaries or the trustees. We'll look at a couple of exceptions to that rule maybe, but most of the time it's the settlers, it's mom and dad who can do these things like amend the trust, replace a trustee or successor trustee, add or delete property. And one of the great things about a family trust is it can help the family after you move on. It can help them avoid probate, right? That's a great thing. The way that they do that is, again, trustees will name a successor trustee. So from a real estate perspective, if I'm an agent or a broker going to a listing appointment, you can see a lot of times on the MLS, and we'll look at this a little deeper. Okay, the real property is held in the name of a trust. Well, who signs for that? Well, generally the person who's on title or the people who are on title as trustees sign first. Okay, that's like a 99% rule. Or people named in the declaration of trust. So we'll look at both of those things here in just a second. Revocable, again, just means amendable. Again, the settlor can do that. Let's look at a couple other definitions. Inter vivos, I've used that definition a couple times. Inter vivos means the trust or the entity was created while the settlor was still alive. So mom and dad creating their family trust, it's usually an inter vivos trust where mom and dad were alive, they made it under sound mind, and that's great. There's another type of trust that we sometimes will deal with called a testamentary trust. Now, these are kind of rare, so we're not going to spend a lot of time talking about them. But sometimes in an estate plan where you have a will or another type of estate plan, or sometimes when mom and dad have their family trust created, but they forget to record the deed to put the property into their family trust, we'll see a testamentary trust. That's created through the probate process where the judge can issue a decree titling the interests of the estate into a trust that has previously been created or that a will or other estate plan has allowed to be created. Again, we're not going to spend a whole lot of time talking about testamentary trusts, that they're pretty rare. So why do you make a plan, or why do you make a trust if you're mom and dad? Well, one of them is to make your wishes known. One of the best ways to keep your kids from fighting over your stuff when you're dead is to let everybody know what the plans are while you're still alive. Okay, some people will do an estate plan that just has a will. Some people will do a trust and a will, and others just have no plan at all. Okay, and there's that's where you go into probate, with a will or with no plan. Some folks will believe mistakenly that a power of attorney will help their family after they pass away. Not so much. Powers of attorney, they cease working once the person is dead, and some of the powers of attorney will stop working once a person is incapacitated. Okay, you've got to really look at the form. So again, family trusts, one of the reasons people do them is to help you avoid probate. Okay, and that only works if you've recorded your property, deeds to your property, into the name of your family trust. Okay, again, forgetting to do that is will cause a testamentary situation where the judge will have to issue a decree. I had an agent, his name's Todd. He called me one time and he said, "Hey Tucker, can you get this listing started? I'm listing this property." He gave me the address. He says, "Hey, mom and dad are dead. The family says it's in a family trust. Can you get the title going?" I took the information down and then started the order on Backman Title and got into the county website to see, okay, what's going on here? And immediately I looked at it, I pulled up the abstract, the title history, and I had to call him back and I had to say, "Hey, Todd, guess what? Property is not in the name of the trust. Mom and dad never recorded the deed." So we ended up having to probate that and create the testamentary trust in that situation. And his very next listing, it was about 2 weeks later, he called me up and he said, "Hey, Tucker, I learned this the last time. Is this property in the family trust?" And you know what the answer was? No. He had two in a row where the family had created a family trust but never recorded deeds. So that's definitely an important thing. Another thing that happens when you're funding your trust or deeding property into the trust is sometimes attorneys are great at preparing family trusts, but they mess up on the deed going into the trust. In order for your trust to operate, you have to have the correct grantor, meaning the names as grantors on the trust deed have to match the names on title. And the notary section and signature lines have to be correct as well. Also, to deed into a family trust, you need the current trustees, the name of the trust, and the current date of the trust. One other item, when you're deeding into your family trust, use a warranty deed. Okay, when you use a warranty deed, if the property has title insurance, the new title insurance policies, at least for the last 10 years or so, will automatically move the title insurance interest for the family trust without doing anything else. If you deed property using a warranty deed from yourself as an individual or a couple as joint tenants to a family trust, the title insurance automatically insures the family trust. Okay, that's for a homeowners or an Eagle policy. When you're deeding out of a family trust, we'll just go over this really quickly. You need the name and date of the trust. Okay, and you also need the recording information for that family trust. So we have a question in the chat. It says, what is you or your client's own property, not primary residence, in a partnership? So when your property is held in a partnership, that is a separate entity, right? And I'm not sure how partnership law works, whether you can have a family trust as a partner. Generally in a partnership, a general or a limited partnership, the title company needs to read the partnership agreement to do something like that. For those who are wondering, I'll type in my cell phone number here as well. Sorry, I'm like the slowest typer around. Sorry about that. So yeah, we can talk about partnerships and things like that a little bit, but let's continue on with our trust stuff. And again, I'm happy to take your phone calls and your emails later on. One of the first things you should do as a listing agent is verify whether the trust holds title to the property, just like we talked about. And there's a couple different ways to do that. One of them is to get a property profile from a title company. Now, I like getting information directly from a title company because they're going to tell you the current vested owner of the property. Okay, and sometimes that's a little bit different than who the MLS shows as the owner. You can also see how long someone has been in title and their current and their last mortgages, right? The last recorded deeds of trust. Okay, so let's look at a county abstract. This is something that I recommend you get when you're listing a property or even as you're making an offer on a property. This is a copy of an abstract from Davis County. Up here, it has the tax name for the year. You notice on this one, it says Barbara D. Hounton, trustee. Okay, if you're looking on the MLS or on county records and you see something trustee, that should be your first clue, right? Hey, it's telling me it's in a family trust. As you look at this at the actual deed from the county, Barbara D. Houghton is trustee of her family trust from March of 2009. 99% of the time, Barbara needs to be the signer. If you get a call about listing mom's house and you're going to meet with anyone but Barbara D. Houghton in this case, you should ask the question, hey, I noticed Barbara D. Houghton is listed as the trustee. Where is she? What's going on? And hopefully you get that answer from the client before you go to your listing. Let's look at a couple of other items. So we can take ownership directly from the county recorder's office. There's another couple ways to do that. One of them is from the treasurer assessor's office. Now the treasurer and the assessor update their tax records or their ownership records once per year. That's the only time when they send out that notice of assessment and that bill from the treasurer's office. They only update it once per year. Now the recorder's office will update the title or update the ownership of the property anytime the title ownership changes. That's different from the county assessor, okay, and from the county treasurer's office. And most of the time our MLS tax data, that comes from the assessor and treasurer records, not the recorder's records. So if you look at the structure of your county government, right, you've got a few different things going on. The recorder's office, they keep track of real property ownership, okay? The assessor's office will give you a value of that property. And then the treasurer's office will collect the property taxes for that system. And in some counties, those systems that they use are they're not integrated at all. Again, the treasurer and the assessor are separate from the recorder's offices. They have different roles. How many of you have ever had someone who buys a property early in the year and then the tax bill comes out or the assessment comes out and it has the former owner's name on it? And they call you and they say, oh no, I'm not the owner of the property. What is going on? We get those calls about every time the assessor comes out. What's happened is your ownership is updated at the county recorder's office, but it has not updated through the assessor treasurer's office because they don't do that. They just do that once a year. So here's a question from Chad. Do you have to renew the trust with the state? That answer is no. Once you record it, your trust is there. And actually, the state of Utah doesn't have copies of family trusts. They're a private document. That's another reason people like them. See, if the property is a mobile home or rented property, yes, you can have that property in a family trust as well. Personally, if I owned a mobile property or rental property, I might put that into an LLC rather than my family trust. Okay, and again, you can make your family trust the manager or member of your LLC. I'd have an attorney do that for you. Okay, so let's go back to our MLS data and let's just do a little comparison. Oh, this is one that came up with one of those property information sites similar to Zillow, right? This one says Barbara D. Houghton, and it has an abbreviation there, TE. Now, I'm a guy, to me, TE means tight end. So Barbara plays tight end. Maybe I don't know if she's a blocking tight end or receiving tight end. No, that just means trustee. So sometimes we'll have these abbreviations, and that gets us into a couple of other interesting situations. So let's look at some of the information that comes on the MLS. Again, the MLS information could be outdated. There was one county in Utah, it was Carbon County, where the information that popped up on the MLS was from the assessor's office, and it was 7 years old. So ownership information from the MLS is only as good as the last time the information was uploaded or purchased by the MLS. Now, in Salt Lake, Weber, and Davis and Utah counties, they're usually doing that twice a year. But again, the MLS does not link to the county recorder's office. Another problem that we see is condensed data. Okay, there's only a certain amount of characters that you can fill in a space online. And a lot of times those areas they're limited to how much information you can put in there. So I ran into this one where on the MLS that was sent over, it said, and I changed the names here a little bit, but it said Henry W. Ford, TE. Okay, on the MLS. When I went to the county treasurer's office, it said Henry and Wendy Ford Trust. And then when I actually pulled the deed, it was really interesting because Henry and Wendy are listed first, but as you read that, they only had 40% of the interest of the real property. Okay, there was a separate trust, I'm assuming brothers and sisters or something like that, with Larry and Sydney that actually had 60% of the property. So you can see kind of how valuable it is to get your information from the recorder's office and actually have a copy of that vesting deed. And again, the title company can give you that for free if you don't have access. If you're in Utah County or up in Summit County, you can get that for free on your own. But if it's behind the paywall, there's nothing wrong with sending a text or an email to your title company saying, hey, can you help me figure out who owns this property and give me a copy of the vesting deed? So again, here's our 3 things that we looked at. This is from a few years ago, but you can see the MLS had not been updated for 2 years when this was created. Okay, so treasurers are usually a year behind, the recorder's right on time. The MLS is usually about 6 months behind. Okay, and anything that you get into with Zillow or something like that, or FastWeb, something like that, they could be years behind, you just don't know. So as a listing agent, what do you ask for when you go into to list a property that's in a family trust? Well, if mom and dad are still alive and they're the trustees, eventually you're going to need to have a copy of the trust, or at least your title company will. The second thing you'll need, or you could ask for if they don't want to give you a full copy of the trust, is called a certification of trust. So with attorneys these days, when they're preparing family trusts, they generally don't hand type every page of the family trust anymore. They'll put the information into a document creation system, and the document information system will spit out the family trust with boilerplate language, right? It just kind of works better that way. So let's look at the requirements for this separate thing that's called the certification of trust. Now, certification of trust is basically a summary of what your trust says. And we can rely on it in real estate. We can rely on it as a notary and as an escrow officer and as an agent, as long as these elements exist. Okay, it says this trust exists. Here's the date of the trust. These are the settlers. Here's the address and identity of the trustees right now. And here's the powers that they hold. It has to say whether the trust is revocable or irrevocable. Okay, most of the time with family trusts, they're revocable. Again, they can be changed. And it also says, and here's how we hold title to real property. If you have each of those elements, believe it or not, the title company or the notary, or you guys as real estate agents, we actually don't need a full copy of the family trust, and the state code backs us up. So this is from our state code. It says if we act on reliance with that family trust, we can assume that it's correct and we can enforce the transaction. So sometimes we'll use these certification of trust. I have a form here that's one of Backman's forms that we will sometimes use. I'll give you an example of when Backman would help you create a certification of trust forms. And it comes from my own family, so that's fun. When my father-in-law was moving out, when he sold his family home and moved into a condo, man, that's a life, right? Condo life, someone else mowing your lawn. Oh, I kind of dream of that. My wife will never let it happen, but I just, you know what? I don't want to mow the lawn anymore. So I went to his house. We helped him move everything, and he moved into one of those pod services. You guys know the pod services. You deal with those all the time, right? So we loaded everything into the pod. His condo that he was moving into wasn't ready yet, so he lived at our house for a little while. And like 10 days later, we had the settlement for him on the seller side for his family trust. And I called him up. I said, hey, Steve, I never got a copy of your family trust. I'd read it before because, you know, it's a family thing, and my wife's a successor trustee, and I knew that he was the only remaining trustee and how everything would work, but that I needed to get a copy of it. And he said, uh-oh, it's in the pod. So we had moved the box with all the trust paperwork into the pod, and it as you know, getting those pods out is not an easy feat. So we weren't able to do that. We created a certification of trust that met all these requirements, right? He signed it, we relied on it, everything worked out great. So let's talk about different issues when you're dealing with a family trust. One of them is delegation of authority as a trustee. So I've got our code references up here. We're not going to read the code, luckily, this time. And our references about certification of trust. And then it also talks about co-trustees. But let's really look at a few items that can happen to a trustee or successor trustee, meaning someone's dead, someone's incapacitated, or someone has been resigned as a trustee or been removed as a trustee. So first off, let's talk about incapacity. Okay, when you have someone who's incapacitated, the first thing that you should do is look at what the trust says. right? That sounds obvious, but a lot of people will make assumptions about what incapacity means, and the trust might directly contradict that. And the trust is what is followed by the beneficiaries and people who are bound by the trust. So generally, a trust will tell you, here's how to determine whether or not a trustee is incapacitated. Sometimes a doctor will render an opinion. Sometimes they require a court order. Okay, sometimes a doctor's opinion is not enough. So incapacitated, if you're before the court, you have to prove beyond a reasonable doubt to a judge basically that someone cannot receive or evaluate information, make or communicate decisions, or provide for themselves for their health, safety, and clothing. So that's kind of the legal definition we use in Utah for incapacity, right? I had a guy in my neighborhood whose family was saying that his mom was incapacitated, and they wanted to take over her stuff basically. And he did a capacity hearing, not because he thought mom couldn't handle herself, but because he knew that she could. Okay, so they brought in medical experts, and the judge ruled that she had capacity, she could make whatever decisions she wanted. And the kids, or the one or two kids in this case, who wanted to sell off all mom's stuff and get the money before she passed away, were not able to do that. So capacity hearings are a real thing. Here's an affidavit that we use when someone has been found without capacity, and you attach to it, here's how we came up with that. Now, if the trust says a doctor's note or two medical professionals, generally you'll attach those two opinions to this affidavit. If the trust says that you need a legal opinion on that, then you attach the decision from the court to this affidavit. That allows generally the successor trustees to take over for that family trust. Here's if you want to read it, we're not going to take time, but it talks just about, here's how we know they're incapacitated. Here's a section of the trust that deals with that eventuality and how we determine that. All right, so let's move on to our next one. Let's talk about the death of a trustee or successor trustee. Okay, when a trustee or successor trustee has died, the first thing that you do again is actually read the trust. Okay, what does the trust say? Okay, generally, if mom and dad created the trust and mom and dad are co-trustees, or they're both trustees of the family trust, when one of them passes away, usually, and again, this is why you read the trust, the other has full signing capacity and authority over that trust. In that case, whether you know who the other trustee is, you do what's called an affidavit of surviving trustee. And within that affidavit of surviving trustee, you say this person has died. This person listed as trustee is one and the same person as listed in the death certificate that's attached. And by virtue of the trust, I am the sole remaining trustee, and I have the authority to transfer, sell, deal any assets of the trust with the real property. Okay. When both trustees have passed away, and there's a question in the chat here. Oh, thanks, Matt. I got your stuff here. When both trustees have passed away, or the only remaining trustee has passed away, you do what's called an affidavit of successor trustee. This is where you're letting people know, hey, the trust is triggered and the successor trustees are now in charge. And the affidavit of successor trustee reads about the same. I am this person. I'm over 18. I need to establish the death of these successor trustees. Here's their death certificates that I've attached to it. And according to this article in this section of the trust, I am now the successor trustee, and I have authority to deal with trustee assets or with trust assets, right? So again, you're proving a couple of different things. You're in all these affidavits or all these eventualities, you're providing to the public record the current status of the trust, the current status of the trustees who are listed on the original deed, and who the successors or the remaining folks or the successors are for that family trust, right? So it's one thing to have it spelled out in your family trust. That's generally not enough, again, because family trusts aren't like LLCs or corporations that are held publicly. They're a private document. You've got to prove to the county and prove to the public record or provide for the public record who has capacity for signature. And that's actually an important part of our REPC. Okay, our real estate purchase contracts, all of them, they all have a section in there that talks about authority of the signers. It says, hey, if this is a trust or an LLC or corporation, a limited partnership or partnership, the people signing this document have represented they have capacity and they can bind the real property and the transaction. That's one of those things that we do in settlement escrow that we take a little bit of a risk there. And that's why your title companies are so particular a lot of times about having things like the full copy of the family trust, or, sometimes the LLC paperwork, including an operating agreement. Or sometimes you require things with a corporation that you might think are unreasonable. Like, how do we know that a president can sign for things? Well, we don't unless we read the corporate documents. Sometimes that the president or the vice president or secretary or somebody like that has to also sign for things. So that's one of those duties, again, that falls under the escrow officer. So let's put ourselves in the position of a successor trustee. Okay, let's pretend that we're named successor trustees, and this is what most commonly happens, right? Our parents have passed away. They created a family trust. Their real property is vested in that family trust, and now they're gone. That's a crappy position to be in. No one likes it when their parents pass away, right? That's one of the first things I want to tell you about is when you're dealing with your clients who are dealing with family issues, it can be a very emotional thing. Like some of the more emotional closings that I've had are people selling their mom and dad's estate. And generally by the time they get to the closing table, they've had a rough time, right? It hasn't been easy for them. Not only are they dealing with all this legal framework that they usually don't know what they're doing or haven't done it before. A lot of times the person at the closing table or the people there are also the ones who had to clean out mom and dad's house, who had to take care of the funeral arrangements, who have to deal with family members who are questioning their authority or what they're doing. It can't be an easy thing. So let's think about this in our capacity as agents and as title folks. How can we make it easier for them? And these are some of those hints and tricks. One of them is we help our people, we help our successor trustees keep good records, okay, and follow the intent of the trust as specifically as they can. And those are two things that are legal terms, right? One of them is called cypress, following the original intentions, okay, doing your best to do what mom and dad asked you to do with their family trust. The second one is a spendthrift provision, which almost all family trusts will have. Okay, the successor trustees, they have to prove that they didn't waste mom and dad or the trust money, that they acted in the best capacity for the trust. So there's a question from the chat. It says, who do you send the affidavits to? Generally, the title company will prepare the affidavits for you. What the title company usually asks for is a copy of the family trust and then original death certificates to attach to those affidavits. So, if you have something that's going on with a family trust, I wouldn't worry so much on your end about preparing affidavits or making the family do that. As long as the title company has the trust and the death certificates, they can generally do that for you. That was a really good question, Madison. Thank you for that. So again, with both of these things, cypress and spendthrift, that's where documentation, paperwork, and note keeping is really important if you're that successor trustee. And luckily for us, in real estate and title and escrow, man, we are professionals at generating paperwork. Woohoo! Like we like to have paperwork for everything. So let's look at our duties again. One of the things with a successor trustee is when a successor trustee is named or a trustee, 99% of the time, you cannot give power of attorney as a successor trustee to someone else. You have to act. So what mom and dad will do sometimes is they'll have 4 kids and they'll make all 4 of those kids successor trustee because mom and dad want everybody to love each other and they want everyone to suffer equally. That's how I kind of put it. And invariably, there'll be one kid who's hard to get a hold of or lives out of the country or something like that. So the family plan is to just have that one kid give power of attorney to someone else to act for the trust. And the trust will not allow you to do that. Okay, you have to act. So I do have an example here of a family. This is the 1%. This is like one of like 3 trusts I've seen that grants successor trustees authority to grant power of attorney. If it doesn't have a paragraph like this one that's outlined in red that says the trustee may appoint an attorney in fact, you can't do it. And again, most family trusts don't allow for that. Okay, so let's think about this for a second. In that situation again, where mom and dad have assigned Their 4 kids, all successor trustees. That means all 4 of them have to sign the listing agreement, the Rep C and every addendum. They have to sign its settlement. They have to sign the 1099 form for the family. They have to be there when the proceeds are dispersed. That's a lot. That's a lot of signatures, right? All 4 people. Realtors, have you ever had to wrangle a whole family together to get signatures? It's not a very fun thing. Even though we have DocuSign and things like that now, still not the easiest thing to wrangle all those signatures. And again, they're signing their name, comma, trustee. Or in some counties, they make you sign your name, comma, successor trustee. Like if you're a successor trustee in Davis County and don't sign successor, they bounce the deed and make you redo the deed. Most counties won't do that, but Davis County will. So we had a situation, I've got a little bit on the thing. And again, I'm not an attorney, I'm not a real estate broker, so get your broker's advice anytime you have something like this. But we were dealing with a guy who was successor trustee of his mom and dad's trust. And every time he had to sign his name, comma, successor trustee. And the poor man had Parkinson's. And it was just getting him to sign anything was just torture for the guy. So the agent, the broker, and our attorney put their heads together, and we put this on an addenda to the real estate purchase contract. And it went through 4 bullet points. Okay, says the seller is this family trust. Okay, this person is the successor trustee. Any signature or any initials on the contract, agreement, or disclosure is in their capacity as successor trustee, and the seller is going to give the buyer whatever they need to feel comfortable about that appointment. So after that, we didn't have him sign his full name, comma, successor trustee anymore. We just had him initial, and everybody was okay with that. Even the lender was okay with that. So, you know, when you're in that situation, there are ways to kind of get around that situation. Again, get your broker's advice, but I think it's a valuable thing to know that you can do. So let's go through this from the Utah Code a little bit. Trustees may resign. Okay, so this is an alternative to having every trustee sign. Like mom and dad made their 4 kids successor trustees, right? And the one lives in Zimbabwe or somebody like that, and they have to sign everything, but they can't because it's really hard. They're 14 hours away. You know, the time difference might be that. That person can resign as a successor trustee and stay as a beneficiary to the trust. That means they get everything, but they don't have to sign all the paperwork. One of my broker friends was his mom and dad had 5 kids. Okay, his mom passed away and his dad remarried a lady who had 6 kids. So there were 11 kids between the 2 of them. And in their family trust, the new husband and wife, mom and stepmom, made all 11 kids successor trustees. That sounds like a nightmare, right? It was. What we ended up doing is the oldest daughter and this broker had their brothers and sisters all resign as successor trustees. They all signed resignation paperwork, right? And then the 2 of them handled that estate. It's something that you can do, okay? And you don't need court approval to do that if they voluntarily do it. This is what the form looks like for a trustee resignation, okay? And you know what? The funny thing is on this form, the one that Backman has prepared, it's notarized. Sometimes on this form that you don't even need a notary on it. You can do a non-notarized section where people resign. You can have a trustee removed. This isn't the proper legal term, but I call it the butthead rule. I don't know, that's probably not the right way to say that, but if someone has committed a serious breach, if they're unfit, unwilling, or persistently fail to act to administer the trust, you can go to the court and have that person removed as a trustee. Now, with your family, Robert, I can share that to you. Yeah, as long as I've got your email address, I'll send that to you. You can have folks removed. Now that can be tricky in family situations, right? Where we had one of our employees who worked for us who their mom and dad passed away, and this guy's sister was named successor trustee of the trust, and none of the rest of the family knew what was going on with the estate or what was happening. And this sister moved in her kids to the house, and they were living there rent-free for a couple of years, and she refused to sell the house, and the family didn't know what was going on. So the other 4 siblings had to sue the sister to even view the trust, and then they had her removed as trustee and were able to sell the property and distribute the assets the 5 ways like mom wanted to originally. So that is a possibility. It can be a little bit tricky, especially around Thanksgiving time, but yeah. If you're a successor trustee, you can be reimbursed from your expenses always. Like if you cut money out of your own checkbook, you pay for things, keep your receipts, and then reimburse yourself from trust funds. You can also be compensated. The code allows you to charge an hourly rate or another amount commensurate with the work that you do. Now, whether or not you should take compensation is a separate question, but the code allows for you to be that. If you're a successor trustee, you have to be loyal. You have a duty to be loyal to those beneficiaries of the trust. That's the only people you have to be loyal to. Okay, as only those people who are beneficiaries. You have to be impartial. You have to be prudent. You have to keep track of all the costs. That's where paperwork comes into it. This little section, 757806 says, if you have special skills, use those special skills or expertise. Okay, the idea is mom and dad or whoever made you a successor trustee in part because you have special skills that can benefit the beneficiaries. Okay, you have to keep good records. You have to collect trust property. You have to inform and report. So this is an important thing. There's a duty to inform and report all the beneficiaries at least once a year after and letting them know what's going on. So the code says after you've been successor trustee for 60 days, in other words, after mom and dad have been gone for 60 days, you need to let people know what's going on with the trust assets, how much is in there, okay, what expenses the trust has, and how those expenses are going that you're paying the bills. Okay, it also says you shall notify the qualified beneficiaries in advance the change in method or rate of a trustee's compensation. If you're going to take money for administration of the trust, you tell the trustees you tell the beneficiaries, excuse me, how much you're going to take from trust assets at the very beginning of the transaction. That just makes sense. Don't do it at the end when people can be mad. Okay, at least once per year, again, you're giving an annual report. Now, this is a fun part. You can be a trustee, you can be a trust fund baby. I don't know if that's the right thing, but you can actually call the trustee if you're a beneficiary and say, I don't want to get this report anymore. I don't care, just give me my money. The code allows you to not receive a report of that if you don't want it. So again, as you're a successor trustee, here's a few things to start doing. One is you review the trust documents. You gather your evidence of authority, okay, that family trust. You get the death certificates. You coordinate if there was a personal representative named in a will or an executor of will who's different from you. You need to coordinate and decide who's handling what. Okay, and again, keeping notes of meetings and conversations. Now, when we say trust asset, that means real estate, bank accounts, other death benefits, and also debts owed to the trust. If mom and dad have loaned people money and they're being paid back, you need to collect those debts on the schedule that was previously agreed to. Collect life insurance where the trust is named beneficiary. You can have a trust named as beneficiary of a life insurance policy. Life insurance is a separate agreement from a family trust. Okay, so in the instance of my grandma, when she passed away, she named all 4 of her kids as beneficiaries. Okay, and then in her will, things were divided up a little bit differently. The life insurance had nothing to do with the will. It was a separate contract that predated the will, and they never changed the beneficiary designation. So dealing with life insurance is a separate contract. If you want that contract change, you have to contact the life insurance company to have them change it, to do a beneficiary designation change. Okay, obtain date of death values for trust assets. If I'm a real estate agent and I'm a successor trustee, I can do a CMA my entire life. That's what you do, right? You do a CMAs. You might want to get a third party to do that for you. That date of death value, either another agent or broker in your office, or maybe even getting an appraisal so that people know that came from a third party. Identify the liabilities, raise cash to pay ongoing expenses, file the final returns for the decedents for mom and dad. If the property's encumbered, you have to make sure that encumbrance remains current, meaning you pay the mortgage or the credit card debt, or you let the credit cards know. We'll talk about credit cards in a minute. You let them know that mom and dad have passed away. This is really important when it comes also to reverse mortgages. With a reverse mortgage, generally you have about 6 months after mom and dad have passed away to get the property sold. Most reverse mortgages are held by the FHA, they're FHA products, and you're dealing with one of a couple different companies. Key Bank has a few of them. Most of the time, reverse mortgages are held by an entity called Novad, and Novad can be a little bit difficult to work with. It sometimes will take us a month to get something done as far as getting a payoff. Okay? And you also have to provide them with death certificates and copies of estate planning documents. One of the duties of a successor trustee, and these are the same duties for successor trustee as it is for, oh shoot, I just forgot the word, wouldn't you know? As an executor or personal representative under a probate, is publishing notice in the newspaper of the death of your parents, of mom and dad. Okay, the reason that you publish things in the newspaper is for deaths that you don't know about as a successor trustee. Okay, now if you're receiving mail from mom and dad and you get something from a Target card, or if it was my dad, it would be a Cabela's card, right? If you get something like that in the mail, you've received notice. You know that mom and dad have those debts, and you're mailing out original death certificates for those things. There could be debts that don't come in the mail that you just don't know about. When you publish in the newspaper, what it does is it cuts off creditor rights, okay, within 90 days of published notice. If you publish the notice in the newspaper of the death of the trustees or of mom and dad, after 90 days, if they contact you to get something, they're out. You could honestly say, hey, you know what? I published notice in the newspaper. You get nothing. You didn't send us any mail during that time. You're done. So that's one of those things. Now, a lot of folks have been a successor trustee, or they have been a personal representative under a probate, and they never publish notice. There's no penalty against you individually for not doing that. It's just a good idea. And most of the attorneys who handle probate and will help you with family trust will help you publish notice. It's really not a very hard thing to do. The nice thing, the code says the individual trustees are not liable to creditors for failing to give notice. So if you forget to tell Visa that mom and dad have passed away, and Visa want to come after you as an individual, they can't. They can come after the trust assets, but you as an individual are held harmless. Okay, investing assets, making distributions, wrapping up trust business. These are all things that successor trustees are doing. Here's the final reporting. So once the trust has been fully administered, you're giving evidence of all this different stuff, out-of-pocket expenditures, evidence of tax returns. Does this sound fun to anybody? This is awful, right? Not only are you dealing with the death of a parent or your parents, you're having to deal with all these other things that, frankly, I'm not good at doing this myself. You know what? My wife files my taxes. I don't know what I'm doing. I have no idea how much money I make, but that's another thing for another day. My wife always tells me I don't make enough, so that's the only thing I really know about that. So here's a couple of items of advice. One of them is you never mix trust assets with your own assets as a successor trustee. What does that really mean? It's the same thing in real estate, how you'd never put a client's earnest money into your own trust account. Okay, you never do that. Okay, you never mix those two things, right? You don't do that with mom and dad's assets either. If mom and dad don't have a separate trust account at the bank, or in a separate account for trust assets and liabilities and bills, then it's your duty as successor trustee to create one. Okay, and everything going in and out of that account, you have receipts for. Don't use assets from the trust for your own benefit unless the trust says go ahead and use the asset. Don't play favorites unless the trust tells you to pay favorites. And the last one is don't hesitate in getting professional advice. Actually, the Utah code will allow you to get professional advice, things like accountants, attorneys, real estate agents, and you can pay for that advice from trust assets, right? You can do that. The code allows you to do that. So here's a few things to do as an agent. Okay, here's kind of your checklist. One of them we talked about is figure out who the owner is from the recorder's office. Okay, don't necessarily rely on what's on the MLS, although most of the time that's going to be correct. Don't necessarily rely on an assessor treasurer website. Figure it out from the recorder's office and have your title company help you do that. They do that for free. Just verify you're dealing with an inter vivos family trust. Most of the time you will be. If you don't know what you're doing, ask for help. Okay, one of the first calls that you should make is to your broker, obviously. The next one could be to your escrow officer. Now, here's the thing. If you're an agent who hasn't dealt with a lot of family trusts, your escrow officers have. Okay, we're dealing with family trusts all the time. And it's one of those economy of scale things. When we deal with family trust, when we're dealing with 20 or 30 in an office every month, we kind of know how things work. If you're dealing with 1 or 2 a year, rely on someone else's expertise. Okay, get that advice. Figure out who has authority, and as a listing agent, prepare to give that information to those that need it. Okay, so who would need evidence of a successor trustee capacity? Well, both the title companies will. Sometimes the borrowers or the buyer's lender will require that, and sometimes the buyer will require that as well. How do I know that Mary can sign for mom and dad's trust? Okay, just have that on hand and ready. During the listing agreement, help your trustees out. Keep copies of all your disclosures in one place. Okay, all the title report, inspections, everything that they sign, their Form 10, seller disclosures. Remind the trustees that they're acting for the trust and not for themselves. Well, what the heck does that mean? Some trusts will have an EIN number, a separate federal identification number for their family trust. And sometimes, most of the time, you're using mom or dad's social security number. Usually it's the last survivor. So just having that ready in a place where you know where it is to fill out the 1099 form at settlement, it can be really helpful. Again, we're addressing buyer side concerns. When you get to settlement or closing, either have somewhere that they can access or come with copies of their closings and have the escrow agent, the escrow officer, combine everything into one spot. That makes the reporting requirements for the successor trustee so easy. I have everything with the real estate. It's here in one place. The listing agreement, the offer, the acceptance, all of our disclosures, settlement statement, IRS 1099, that's all in one form. It just makes it so much easier for them. They can request the settlement statement and 1099 form early. I would. And then remind them about having original death certificates. I've made a lot of trips to the county health department for folks who thought they had an original for mom and dad's death certificate, and all they had were copies. Okay, we have to have the original death certificates. Another thing that families will sometimes think about is, or forget about is, what's going to happen with the money. Okay, a lot of them have plans about what they're going to do with the money that they get, but I'm talking about specifically at settlement, where's the money supposed to go? And it gets back to that discussion or that little chat we had about not commingling funds. Okay, the funds for the trust should be dispersed by the trustee, not by the title company. So what does that mean? We had a lady who came into settlement and she had all of her siblings' bank account information. She said, I want 1/4 to go to Johnny and 1/4 to Jane and 1/4 to Jenny and 1/4 to me. And we said, no, we can't disperse the trust funds for you. We have to send it to one account and you have to do the disbursement yourself. Does that make sense? It's the trustee's job to do the disbursements. So here's a few resources. These are just really good resources no matter what you're dealing with. So the Utah State Bar has probate and trust resources through their website. Another great one is the utahcourts.gov or UT Courts website. It has a whole estate planning and probate section of the court, like how to do that. And these links are on the handout that I'll send to you. You can read Title 75 of the Utah Code if you are a glutton for punishment and you want to read code sections. Heck, man, knock yourself out. Read the state code. Also, you're paying dues, man. You're paying for the legal hotline. Okay, if your broker doesn't know, if your title company doesn't know, call the legal hotline. Okay, together with your broker and figure out what you're supposed to do to protect yourself as an agent. Okay, again, if you're a successor trustee, you can hire your own attorney and pay that attorney from trust funds. But as a real estate agent, you need to protect yourself with the legal hotline and make sure everything is done. Okay, all right, before we move on, does anybody have any questions just about family trusts in general? Because we're done with that section of the class. I know it's kind of like drinking from a fire hose, but we only got an hour together, so I thought we'd go quick.
Can you hear me, Tucker?
Yeah, go ahead.
Hey, anybody that's on Zoom, just unmute yourself and ask a question. But I just have a comment. I'm noticing as you're going through this, how few offers I write that are in the name of a trust, and how few people actually have their vested title protected this way. So it might be a good reach out to our family, friends, start a conversation, direct them in the right direction to maybe check into this and offer that value to them. I have one more question. Yeah, we got a question back here, Tucker.
Yeah, there's a couple in the chat we won't miss either. So Madison and Robert, we haven't forgot about you. Go ahead, guys.
Might jump to a whole nother class, but a trust still has to pay capital gains tax. Do they pay that before they distribute assets to the beneficiaries or after? I mean, do they?
Yeah, I would say at the same time.
What if they don't know what the capital gains tax will be yet?
Yeah, you know, before you do your final distribution, you make sure everybody gets paid, including the taxes. What a lot of families will do is they'll have an accountant or an attorney, somebody like that, estimate what the taxes will be. And then they hold a little bit more than that amount in the account. So you can do an initial distribution to the trustees and then a final distribution after the final taxes are paid. I think that's how most people will handle it. That's a really good question.
Robert speaking.
Go ahead.
I'm sorry.
Yeah, go ahead.
Jason.
Oh, I think.
Yes, tell me.
Oh, I think Robert's taking a phone call. That's okay. Madison, I'm going to answer your question. When someone is removed from being successor trustee, who takes over those responsibilities? It depends on the type of removal that was done. I'm going to default to say, what does the trust say? So a trust will name usually several successor trustees and kind of a, I don't even know how to describe it, like a pattern of who the successor trustee will be. Most of the time, it's going to be the next named successor trustee. Now, having said that, if it goes before a judge or before court, the beneficiaries can choose from among them another successor trustee to take over those responsibilities. Hopefully that makes sense. Okay, Robert has a question. It says, okay, one person received the check. How do you protect yourself if that person screws over the rest of the brothers? I don't know, Robert, are you speaking from personal experience? Hopefully not. That's the whole purpose of having a final trustees report. Okay, to figure that out. If the person has acted as a spendthrift or wasted that money, you can take that person to court and have them held liable for that. Okay, that's a good question. The courts or the process relies on people being honest, and not all people are honest. Carrie says, thanks for the great class. Can I get the recording so I can go through it again? We'll talk to Jeff about that. I think he's been recording things. He might make that available. Lynn says, can a trust help in any way with liability protection? Make it more difficult for someone to pursue assets? The answer to that question is yes. It's very difficult to pierce a trust in when you're being sued. It's hard to do that. So yes, that is something that can happen. It's the same reason that people will get an LLC, right? Or form an S corp. The trust is a separate entity that is not the person. It's not to say it can't be pierced through a lawsuit, but it's very rare, very rare. Conrad, I'll send a copy of the slides, a PDF version to everybody, as long as I have your email address. That'll go through to everybody. Okay, Jeff, back in the classroom. Any questions from there?
I have a question.
Yeah, go ahead.
I did set up a trust, but I haven't changed the house into the trust yet. And
Yeah.
So where would I go to do a quick claim deed and put the trust on the house?
Yeah, I would go to your title company that you deal with, talk to your escrow officer. A lot of times they can help you with an accommodation form, and I
Okay.
would use a warranty deed to do that. Yeah, again, what you'll need is the current name of the trust, the correct date of the trust, and the current trustees.
Okay.
That's the best way to go about it. Good question. Okay, Jeff, anything from the group that's sitting there in person? I see Michelle pacing back and forth nervously in the background.
She's hungry.
I can tell.
Hey, while we're seeing if anybody has a question, you guys that are in Utah that want CE credit, if you just do a favor and make another comment in the chat, just let us know you're still here. Anybody have any questions?
Hey Tucker,
Yeah, go ahead.
we've got Joel and Yancy from Equity Home Warranty. Do you want to pull up their website and then they're going to take a few minutes to just share some of their services?
Yeah, you bet. Let me get on that.
Perfect.
Oh, look at you go. Thanks for doing that, Todd. How you doing? Hi, guys.
So it sounds like they might be a little bit new for you guys, but I've known these two for a long time. Joel has been in the mortgage and title industry where he's now an owner of the equity. And then Yancy has been a
Well,
real
that's not
estate
it.
agent and now has owned. How long have
Come
you
on
guys
up
been
here.
in business now?
Well, I was a real estate agent, just to date it, from 92 to 2002. And then I've been doing home warranty ever since, so 20 years now.
Okay.
And so I know what you guys have been doing. So I knew that there's tickets in there, so be careful passing them out.
Oh,
That
sorry.
might be your ticket. No, we're gonna give away some stuff.
Oh,
So make sure.
I should have peeked first.
Yeah, they all have one. They all have one, so if you didn't get a ticket for that one. So when you open them up and take one, take one back here. These are, those aren't tickets.
Oh.
We were trying to be a little ahead of the game there. Hey, thanks for pulling that up again, Tuck. So
You
yes,
bet.
you get to know who we are. I'm Yancy Scott. This is Joe Hawley. We're Equity Home Warranty.
Man, stand up here so
Oh,
the
hey.
guys on Zoom can see you.
Oh, hi, guys.
They can hear you on that.
Good
mic.
morning, everyone.
Oh, you're so good looking anyway.
I do have to make a disclaimer though.
Go ahead.
Uh-oh.
This is what Joel normally, he's like this beard, he took a challenge to see if he could grow a beard for a year. So he's coming off. But this is what he normally
February
looks
1st,
like.
I got like 1 week.
You
1 week.
win.
2 weeks ago.
Thank you. That's my partner. He grows one heck of a beard, right? It looks good. Yeah, so a little bit about us. We've been around for about 7 years now. We started Equity Home Warranty back in 2014.
But we've been in the real estate industry. Yancey's been in it 30 years. I've been in it for 25 years. Probably not as familiar faces because we're up in the Davis Weber area, but we do service and cover the whole state of Utah. So
We do a lot of St. George and a lot of
Right.
other ones too. So we're
we cover a lot of the rural areas, some of the other home warranty companies well. So
we're more of a boutique style. So if you're looking for personalized customer service, that's what we've got. When you deal with a claim with us, you're dealing with a real live person. We treat every claim like it's on our own home. So you get really good personalized customer service. You're not a call center. It's good stuff. And you deal with either Shay, Tasha, or Kimberly, or Joel and I. And it's an amazing experience. We got about 70 contractors on our network. We are A+ rated through the Better Business Bureau. We're proud of that. Customer service is our number one. You guys sound like you're big on service.
we're old school guys, like I said. He's 30 years in, I'm 25. We still believe in answering our phone every single time. We believe in face-to-face. We believe in answering our phone every single time it rings. So we're old school guys and we've adopted that mindset and that's how we run our business.
Yeah.
So what we're gonna do, sorry folks that are via Zoom, you don't get an opportunity to win, but
No virtual tickets.
yeah.
Yeah.
So what we're gonna do is we're gonna just draw some tickets and then we're gonna explain what we offer and the different plans we have on our with our home warranty company. So would you mind, you wanna pick one out of there?
You be the picker.
We don't
Then we're not in trouble.
we don't like to be responsible for.
Yeah.
They're upside down, guys.
That's right. Just grab one.
So we read it?
Yeah, just read it.
358-3917.
Okay.
Pick a color. Oh, open to the first page of the brochure too. So these umbrellas will make sense. Go ahead and pick a color. You want the blue. Okay. So this is our $500 plan. You guys will see it is $500. It's not $600. So you guys probably know, a lot of the home warranty pricing went up to $600. That's the best plan that a lot of the competition is offering. We have left ours at $500. We don't have any plans to raise them up to $600, and we're covering everything the $600 folks are covering, and more. I mean, I know that we're covering water softeners, for example, and radiant and heating systems and boiler systems, and some of the competition isn't. So that is our best plan. It's $100 less than most of the competition out there. Coverage is the same, if not better. And one of the nice things about us only charging $500 is I think the mindset out there is the best plan is $600. So everyone's writing in $600. Well, we turn that into a buyer's credit.
So that's not our money, that's the buyers. They get to use that how they see fit. If they want to rekey their home, they can take that out of the $100. If they want a furnace or AC tune-up, they can pull that out and use that. Or if they just need a service or they make a claim and need to cover the service call, that money's there for them. So we let them know that it's there for them. And so it's a really awesome program.
What is their service call?
$60, and that's probably the cheapest one out there as well.
Yeah.
We're not the biggest guys, we're not a huge company, but we believe that we're the best. We provide the best customer service, and that's what allows us and affords us to leave our pricing the same.
Now, one of the other cool things out there, let's draw one more. Do you want to do it one more time? Draw your own, go for it.
All right.
I dare you.
She just raised her.
Okay, so.
Yeah, there you go.
3916.
3916.
Okay, pick a color.
Black.
Black. So that's a $400 plan. The difference between the $400 plan and our $500 plan is it doesn't include washer, dryer, refrigerator. That's the only difference. So if you guys look on there and say, okay, they're bringing their own fridge, their own washer and dryer, now you've got the same plan, but if they're going in and saying, hey, I'm buying a new, they're not including a fridge and you only got a new washer dryer, then put that $400 plan down. Even if you have $500 or $600, now you got what? You got $200 credit. Now we have, I mean, that's the thing. Every home, you guys, everybody's pushing like one plan for everything. We offer different plans because every home is different. So allow them to take advantage of the extra money that's left over. We want them to use it. We cover,
Customize it, yeah,
Customize
customize their own plan.
we cover guest homes, we cover pools, we cover wells, we cover septic tanks. Those are all à la carte items. But if you're selling, Jeff, you get one of these big multi-million-dollar homes and they got heating and they need a guest house coverage, it's $150. We got new construction, you guys, for $500, and that's for years 2, 3, and 4. I mean, that's only $135 a year. It's good coverage. It's our basic coverage, but it's still covering the big expensive items. So we'll go over that.
Let's do another ticket.
3920.
Yes.
Okay, Jeff, pick a color.
No. Well, Ashley took mine, so I'll go with green.
Why is someone choosing red?
Use, right?
Oh,
Use, baby, use.
So the green is not an actual plan that we offer, but what the green represents is a 2-year plan that we offer. We were the first home warranty company to get a state-approved 2-year home warranty. And so you can take any of these plans we offer, whether it's a 300 or 500, simply double the cost and have 2 years of coverage. The benefit of doing 2 years up front through our company is we give the first year rate the second year as well. Okay, so we're not, normally after they expire, it would go up $100. We do offer renewals and we would raise it to $600. You know, by doing the 2 years up front, we're offering first year pricing for both years. Does that make sense? So you're saving your clients $100 off on that second year by doing 2 years up front.
Now, let me just throw this at you too, you guys. I think we're one of the only ones out there still offering a $300 plan. And if you look at that $300 plan, what it covers, if you throw $600 in there, you're still getting the water heater, the furnace, the air conditioner, the dishwasher, the disposal, the built-in microwave, the electrical, the plumbing leaks. We're still covering all those for $300. What we don't cover is typically, it doesn't come with like upgrades. Let's say on a $300 plan, if they have a water heater go out, we'd replace the water heater, but they have to pay for their expansion tank and whatever code upgrades are there, which is usually about $300 or $400, okay? But they're still, let's say if you got a house and it's got an old water heater, but everything else in it is great. Well, you're thinking, let's just do the 2-year plan of $300, and then we're covering the expensive items for 2 years. I mean, it's still there to do it for $600. It's a heck of a deal. So again, we look at claims, you guys, it's not a bad thing. Once we have a really high retention rate, once we get them as a client, they stick with us. When we pay the claims, they stick with us. Our renewal rate's extremely high because people see the value and we give it to them in payment plans if they want it. Again, a lot of them fall in love with us. We become friends with them. We're covering their homes. So it's a good thing. Let's draw one more. Any questions?
Well, two more, but.
Two more.
18.
Me.
Hey.
Hey.
I'll do
You
that.
better, there's pressures on, you better grab the red one, you're gonna get punched over here.
You want to talk about the red?
Yeah, so,
I was thinking that.
The red, that's our, that's the plan we offer for $450. If you're needing a plan that covers the refrigerator, but you don't need a washer dryer coverage, that's the way to go, is the red, okay? Let's do the last one, and this is one of my favorite colors.
Hey, guys, we did have a question from the chat.
Cincinnati Bengals fan.
2-6.
Sorry, Hey, there you go, back there. So the orange, that is our basic plan. Again, that's the one that still covers a lot. You guys, if you have a house that's clean, it's got newer furnaces, you're not worried about so much, but you've got a place to put a home warranty there, and you still want it. I'm telling you, nothing's built like it's used to. I don't know if you guys have bought appliances in the last few years, but they're not good. I've had them out of my refrigerator twice since 2 years old. Built to break. Yeah, they are built to break. So, you know, it's still, even though the plan that's on there, it's good. We know that EXP is 100% cloud-based. You can order online, place your claim online. You don't need any passwords, you don't need any codes. We see it, it comes to you instantly. Our people call you back in 5 minutes once the claim's placed to confirm that address is been taken care of. Again, the orange plan is the one that we do offer on new construction. So that's years 2, 3, and 4 for $500. So if they have a new house, you want to put it on there, they don't want to deal with the manufacturer's warranty, then we'll take care of it. Okay.
Also on the orange plan, guys, this is really important. We offer a complimentary seller's warranty.
Every listing.
Okay. We've been in bid, it'll be 8 years this July, and we've never invoiced a seller once. Okay, we do cover seller's claims for free. We ask that you work with us to try to get the buyer out of it. You know, that's only fair, right? And if we don't get it, we're not gonna get all upset and fire off an invoice, okay? We don't do that. We offer it for free. We cover seller's claims. We keep up the good faith in you guys to negotiate with the seller's agent to put it with equity.
What happens when there's a seller's claim and the buyer doesn't buy the policy?
And then we're out.
No.
And that's just,
That's
it
just a marketing risk you guys are taking.
is.
We're even about $40,000 a year.
But when we're offering them, we're also getting a lot of the buyers out of them, especially when we cover, for example, we replace a water heater. That's a win-win for the buyer and the seller. And so generally, nobody has a problem giving us the buyer's warranty because those are what we get paid on.
So one recommendation for you guys when you get a listing, and it's just kind of like step one, add the warranty to the listing, right?
Yeah.
Don't forget to mention that there's one in place when you get your offers, especially if you're working with a home warranty company that you have a relationship with, you like, you know they're gonna do good. So they don't lose that seller's coverage. If you just say, hey, yeah, we're agreeing to give you $500, $600 for a home warranty, we've got one in place, we appreciate you at least checking them
You
out.
just said you want to work with us. That's exactly what I was gonna tell you. So you're perfect. No, you're good. Now,
We'll tell you guys though, no other competitor when it comes to home warranty is offering what we are. They're really not. We got the free seller's warranty. Our plan is $100 less than everyone else. We're covering the same items that the $600 people are covering. So
and we bring a really good lunch.
Yeah.
Let's get some-
we brought a new certified guest.
Hey, Jens and
Or
Joel.
up in Weaver Davis.
Oh, question chat, go ahead.
Hey, one more question from the chat. Robert wanted to know about mobile home protection with home warranty.
Yeah, we cover them. Yeah, as long as they're not on wheels at the time. Like if it's actually parked and skirted, we'll cover them, same price. They're
Same
actually-
price?
Yeah, same price. Everything should be cheaper because those are cheaper, but they're about 3 times the amount to fix. Cause you gotta buy
Yeah.
all the, like, you gotta get a manufactured home furnace. I can't buy those for what I can get a normal home furnace for. They're like 3 times as much, so, but we do cover them. Yeah, we don't care.
Great, thanks, guys.
In Weaver County, are you guys down here in Salt Lake?
Oh, yeah, we're down here. We come and Joe and I are down. We hop into this office.
Our office is up that way, but we cover the entire state. We have a full-time sales rep in southern Utah. We go out to Vernal, we go out to the Vernal areas and we see our people out there, so.
We've had a
We're just
couple
all
reps here in Salt Lake. They just want a job they don't want to work. So Joe and I are just making them around. So we're looking for somebody here to know something.
So how come you guys on service calls?
24 hours.
24 hours.
Yeah, they're there. We've got our contractors are thick. We do a lot of business in Salt Lake.
I have never heard of you guys.
Yeah.
I mean, that's crazy.
Yeah. we do a lot.
Has anyone heard these guys?
I've heard on Connect Utah, people have recommended you.
Good.
Awesome, I'm super happy.
Thank you for sharing that.
And how old is the company?
It's 7.5 years. We opened July 1, 2014.
We got social media. We got a guy that we've hired. We're working on building our name. The reason you have it is we're both from up north. So we got a really strong presence, like I said. We do a lot of business up in north. We got a really good rep south. And then Joe and I are trying to feed in between when we have reps. and maintain just the business that we already
We've
have.
had
So
some
we'd love to
tough-
expand. into
We've
that.
had some tough experiences with sales reps down here.
Yeah.
No,
So-
I'm really excited about it because I've actually talked to my people out of keeping that $600
Yeah.
and just keeping it, you know, in case they have some things happen. You know, it's.
Well,
it's
guys,
just
that's
like
why we
more
do these
expensive.
things, right? I mean, it's relationships, lead to relationships. So it's Debbie, you know, to Michelle, that brings in Tucker, that brings in you guys. Often we're not gonna bring somebody that's gonna embarrass us. So there's usually somebody we want to share,
Well, and
right?
I
So,
want to just pipe in, you know, as a title company, we have a lot of the warranty companies come through. As a matter of fact, we have a spill of flyers in all of our closing rooms. But generally, there's two companies that are, you know, through the agents that they have earned their good reputation. And that's why there's only mainly two that I really only let come to do, because my name's on the line as well. So
right.
I
right,
just
for sure.
appreciate them. I've known them personally for a long time. I know what they say. They will back their word up. Like I said, I've known them for a long time.
Here's how Joel and I do it too.
With that being said, we brought some $5 hot and ready pizzas for you.
If you want anything from us,
Thank you. They're ready. They're not hot
yeah,
anymore.
if you guys, we don't look at the contract. It would be Jeff calls and says, hey, I got a problem with this furnace. We do our deals together. I'm like, let's get somebody out there to fix that furnace, make sure this bill gets done. That's how we work.
Love it.
We don't go through the, oh, well, this isn't covered because it's got a dirty filter, or it hasn't been maintained. Look,
There's a lot of fine print to sift through on those home warranty contracts, and
we're just not getting deals.
we don't try to use that to our advantage. We make it just a pleasurable experience
I have
for
a
everybody.
question,
Yeah.
and I can't believe I'm asking this.
Go
I'm
ahead.
a little embarrassed. I've never had a listing with, and offer us a warranty, a home warranty. Is it during the contract?
Yes, well, it's listed.
So in case their water heater goes out during the listed, or during the contract, that's when it was taken care of.
Correct.
Okay.
It's
We
not,
got
it's now, some on the seller's warranty, it's not there to take care of the list of items that the inspector.
Yeah, no.
and the
I'm saying
appraiser
like,
find.
if they had a flood or they
Yeah,
had like
just
something
during,
happen.
just while it's listed.
If it happens during
If it
the
happens
listing,
during-
not a pre-existing, it's like, hey, this first piece of shit was going on.
Yeah.
That's what we don't do, but we have had people try that, so that's why we gotta at least bring that up.
Okay.
But that's where we eat probably sometimes $10,000-$20,000
Yeah.
in water heaters, is because if it happens, almost every time we get them to come over with us anyways, if it's listed. But like Jeff said, if it's listed, just put in the notes, home warranty's already with equity,
Yeah.
that's what we're offering, shove us out, and we'll offer $500-$600 for every year you can do. And then we always convert them, and if you don't, no big deal, they got a water heater, we save them $1,200, they're happy, you're happy, and we'll get you on the next
Our
one.
name's good.
Okay.
Yeah.
So on that seller's coverage, you don't have like a max, because I know the other ones have a max, like the.
On furnaces, we do, so.
Well, even water heaters are really expensive right
We don't
now.
have water heaters though. Joe and I stepped up, we're the owners of the company, so we like, the water heaters, we'll just eat them. They gotta pay for the upgrades, but on furnaces and air conditioners, we set our limit on sellers for $500, but everything else is no limit. And
That's
it's just
really
not-
big. The other warranty companies have either stopped that or they've got limits now.
Ours is 500 on the heating and AC, but that's it.
That's
And
still,
we don't do fridges, and like, it's a $300 plan, and it's limited to 500 HVAC, but water heaters, we're still a go.
that's what you should know, Sam, is that it's like a $300 plan. And
Okay.
It's not your fridges, washer dryers, the things that they can.
Yeah.
it's just
But-
kind of a
but if it's
backup
built
plan
in-
for your seller.
Yeah.
You don't have to put it on the list if you don't want to.
You don't have to.
And it's not gonna, right, it's not gonna be a fix-all, cover-all for a seller, but it's gonna assist them. If something goes wrong, it's going to assist them in offsetting some of the costs.
Here's what I would do. I wouldn't put it, if you're gonna put it on the seller's coverage, don't put it in the remarks, because they're just gonna make the assumption
Yeah.
that you are offering, and it's gonna be an ask, right?
Right.
A lot of people aren't asking for it right now, because they want to be competitive.
Yeah.
So bring it up when you're under.
We can't wait for that to change. We hope
Yeah,
it
that's-
does.
Right?
That's my
Yeah,
worry. So-
That's probably killed.
Do I put it in place, like, say I have a listing coming up in a week, do I put it in place right now?
Just
Or
a
do I
week,
do it when they
Just
go under contract?
day listing.
Yeah. The
Okay,
day you
Once
list,
it's
day you list it.
Okay.
The day you put it on the MLS.
Call Joel and I will walk through it,
okay.
whatever one you like.
Yeah, I mean,
I'm funny.
the website's super easy, but you can also just send us the info and we'll do it for you if you want to.
Okay, cool.
Any other online questions?
And Probably.
We lost most of it. They're like, no lunch for us, we're out.
Yeah, we'll
Sticking around and
Yeah.
have
we'll stick around and eat
fun.
lunch with you guys, if that's all right.
Yeah,
and Answer
absolutely.
any questions.
We
you might
brought
have.
pins, chapsticks, you guys are in for a treat, this little place we get this from, Tug has, they got amazing salads, salad rolls, All homemade bread, go get it.
I just asked her what this
Appreciate
is
the
and she
opportunity,
does
guys.
it now.
Appreciate being here. Thanks for the opportunity.
Yeah. Hey, thanks, Chad.
Thanks, guys.
Thank you. Yeah.
It's a highlighter.
Oh, is it? Oh, I didn't open it.
I was wondering the same thing.
Don't look at me like that. She didn't even know. Oh, I said, what is this? Hey, Tucker, thank you. Appreciate you. Great training. I'm sure some will reach out to you for more questions. I'm gonna share this video with my team and I put my email in there if anybody else wants a copy of it. So let's stay in touch.
Hey, thanks, guys. Really appreciate you.
Okay, thanks, man. See you guys.
Thanks, Doug.
Thank you.